Good morning, friends. Today I will discuss with you important judgment of the Honorable Supreme Court of India, which will change the whole concept of dismissal in default. Generally, when there is vacuum in any act, I am talking about Section 138 of the Negotiable Instrument Act. And when there is vacuum, then we have to take the help of provisions of the CRPC. In this case, going nutshell, the complaint of the complainant was dismissed in default for not appearing at the proper date. But the case was, the progress of case was that he had appeared in all earlier dates, and even he was duly cross-examined. And in the later stage, due to misunderstanding or misinformation, he could not reach or attend the court, and his application was dismissed in default, which should not have been done by the learned magistrate, as he can easily decide the matter on merit, as he was duly cross-examined and he has closed his evidence, and it was the turn of the accused to put his evidence, and uh, he may not be there, that matter can have been decided with on the merit. And he approached the Honorable High Court. That too could not decide the case in proper manner. And it also took a different view. That's why the case came before the Supreme Court of India. While criminal appellate jurisdiction, I'm telling you the number, that is criminal appeal number 6572664 of 2023, arising out of SLP criminal number 8672-874 of 2020. In this case, the appellant is BLS Infrastructure Limited and respondent is Message Rajwan Singh and others. What the judgment and the details are, I am discussing with you. These appeals by way of special petitions are directed against the judgment and order dated 7th November 2019, passed by the Delhi High Court, dismissing CRLLP number 315 to 322 of 2019, filed by the appellant against the order of the Metropolitan Magistrate under the NRI Act, that is South East Circuit Court, New Delhi, dated 25th of January 2019, dismissing criminal complaint numbers. There are 5 complaint numbers for non-appearance of the complainant. The short question that arises for our consideration in the appeal is whether, in the facts of the case, the learned magistrate was justified in dismissing the criminal complaints for non-appearance of the complainant, even though the statement of the complainant has been recorded and by order of the learned magistrate dated 26th of October 2017, the complainant's evidence was closed with a direction to list the matter for recording of defense evidence, as also for consideration of application under Section 311 of the CRPC filed by the complainant. To appropriately address the aforesaid issue, it would be appropriate to give a brief sketch of the facts given rise to the appeal. The appellant in all filed 8 complaints against the respondents under Section 138 of the NI Act 1881. 3 complaints were filed in the year 2011, 3 in 2013, and the remaining 2 in 2017. Out of the above 8 complaints, in complaint number 621742/16 and another 2 complaints, the complainant was subjected to cross-examination. On 26th of October 2017, the learned counsel for the accused made a statement before the learned magistrate that the cross-examination of the complainant as made in the above 3 cases shall be adopted in the remaining complaints. So, on the basis of the above statement, the complainant's evidence was closed and cases were directed to be listed for recording of the defense evidence. At this stage of defense evidence, an application was filed by the complainant under section 311 of the code for summoning certain witnesses. While the matter was pending at this stage, appellant's counsel misled the appellant into a belief that appellant's presence is not required as a settlement was being negotiated. It is the case of the appellant that in these circumstances, the appellant did not appear and ultimately the complaints were dismissed for non-appearance, wide order dated 25th of January 2019. The order dismissing the complaints for non-prosecution was subject to challenge before the Delhi High Court through 8 separate petitions, which came to be dismissed by the common order dated 7th of November 2019, impugned in the appeals. Now, Honorable Supreme Court heard Shri Maninder Singh, learned senior advocate, appearing for the appellant, and Mr. Samrat Nigam, learned advocate for the respondents. The learned counsel for the appellant submitted that the learned magistrate, while dismissing the complaints for non-prosecution, lost sight of the proviso to subsection 1 of the section 256 of the code. It is submitted that the said proviso enables the magistrate to dispense with the attendance of the complainant and proceed the case where the complainant is represented by a pleader or by the officer conducting the prosecution, or where the magistrate is of the opinion that personal attendance of the complainant is not necessary. It is submitted that as the statement of the complainant had been recorded and the complainant was also subjected to cross-examination, there existed admissible evidence on record in support of the complaint case. In these circumstances, even if the complainant was absent, the learned magistrate could have proceeded to decide the case on merit. Thus, the order of the learned magistrate stands vitiated for having failed to notice that there existed evidence on record enabling the matter to proceed even in the absence of complainant under the proviso to subsection 1 of section 256 of the code. It is urged that the High Court also failed to notice the aforesaid aspect. Consequently, the orders of the High Court as well as of the learned magistrate are liable to be set aside and the matter be restored to the stage at which the learned magistrate has dismissed the complaint. In support of his submission, the learned counsel for the appellant placed reliance on the decisions of this court in Associated Cement Company Limited versus Keshavanand. Second is Shri Anand versus Basumati Chandrasekhar. And third is S.R. Krishna versus S.R. Reddu, who is dead by his LR and others. And the learned counsel for the respondent submitted that subsection 1 of the section 256 of the code mandates the magistrate to acquit the accused if on the day appointed for the appearance of the accused or any day subsequent thereof to which the hearing may be adjourned, the complainant does not appear. It is submitted that since it is not in dispute that the complainant had filed an application under section 311 of the code and the complainant remained absent from the proceeding, the learned magistrate was justified in dismissing the complaint for non-appearance of the complainant. It has also been urged that if there is any technical defect in dismissing the complaint for non-appearance of the complainant, the same be treated as an order of acquittal as per provision of subsection 1 of section 256 of the code. So, having noted the rival submission, before Honorable Court proceeded further, it said that it would be useful to notice the provisions of section 256 of the code, which are what it says. It says non-appearance or death of complainant. If the summons has been issued on complaint and on the day appointed for the appearance of the accused or any day subsequent thereto, which the hearing may be adjourned, the complainant does not appear, the magistrate shall, notwithstanding anything herein before contained, acquit the accused, unless for some reason he thinks it proper to adjourn the hearing of the case to some other day. Provided that where the complainant is represented by a pleader or by the officer conducting the prosecution, or where the magistrate is of the opinion that the personal attendance of the complainant is not necessary, the magistrate may dispense with his attendance and proceed with the case. The provision of subsection 1 shall, as far as may be, apply also to cases where the non-appearance of the complainant is due to his death. So the plain reading of the provision to subsection 1 of the section 256 would indicate that where the magistrate is satisfied that personal attendance of the complainant is not necessary, he can dispense with the attendance of the complainant and proceed with the case. Such a situation may arise where complainant's prosecution evidence has been recorded and to decide the case on merit. Complainant's presence is not necessary. Now, coming to the cases quoted by both the parties. In the case of Shri Anand Supra, addressing a situation where the complainant was absent but had already examined his witnesses, the court observed. Section 256 of the code provides for disposal of the complaint in default. It entails in acquittal. But the question which arises for consideration is as to whether the said provision could have been resorted to in the facts of the case, as the witnesses on behalf of the complainant have already been examined. The date was fixed for examining the defense witnesses. The appellant could have examined witnesses if he wanted to do the same. In that case, the appearance of the complainant was not necessary. It was for her to cross-examine the witnesses examined on behalf of the defense. After observing the above in paragraph 15, it was held that where the prosecution has closed its case and the accused has been examined under section 311 of the Code of Criminal Procedure, the court was required to pass a judgment on merit of the matter. Now, the second case which was quoted by the parties is Associated Cement Company Limited. The purpose of inserting a provision like 256 of the code was discussed, and in light thereof, in paragraph 16, it was observed as under. What was the purpose of including a provision like section 274 in the old code or which is 256 in the new code? It affords some deterrent against dilatory tactics on the part of the complainant, who set the law in motion through his complaint and accused he is perforce to attend the court on all posting days can be put to much harassment by the complainant if he does not turn up to the court on occasions when his presence is necessary. The section therefore affords protection to an accused against such tactics of the complainant. But that does not mean if the complainant is absent, the court has a duty to acquit the accused in vitro. So, after observing as above, it was held that where the complainant had already been examined as a witness in the case, it would not be appropriate for the court to pass an order of acquittal merely on non-appearance of the complainant. The order of acquittal was set aside and it was directed that the prosecution would proceed from the stage where it reached before the order of acquittal was passed. So, in the instant case, there is a specific agreement in the special petition that the appellant had led its evidence in the case and thereafter had moved an application under section 311 of the code to summon and examine further witness. In paragraph 5 subclause U, it is stated that the trial court as well the high court did not take into consideration that the complainant's cross-examination has been over in complaint number so and so, and no cross-examination was sought in other cases. Rather, CW1, the cross-examination in the above three complaints cases was adopted. There appears no specific denial of the above said factual position. So we find that neither the High Court nor the land magistrate has taken notice of the above said position. Both the courts below that failed to consider whether in the facts of the case under the proviso to subsection 1 of the section 256, the court could proceed with the matter after dispensing with the attendance of the complainant. Further, if the complainant had not appeared to press the application under section 311 of the code, the land magistrate could have rejected the application under section 311 of the code and proceeded with the case on the basis of available evidence. We therefore are of the considered view that the land magistrate was not justified in straightway dismissing the complaint and ordering acquittal of the accused on mere non-appearance of the complainant. The High Court too failed to take notice of the above aspect. Thus, the order impugned are liable to be set aside. For the reasons above, the orders of the High Court as well as of the land magistrate are set aside. The proceedings stand restored to their original number on the file of the land magistrate, and the prosecution shall now proceed from the stage where it was when the order of acquittal dismissal of the complaint was passed. So, the Honorable Supreme Court allowed the appeal on the above said facts, and the case was restarted. So, when there is already provision existing, sometimes the courts fell short of that site of the judgments or provisions, and the Honorable Supreme Court had to intervene in the case. Now, after this, the whole scenario has changed, and the magistrate will think twice before dismissing the complaint in default when he can decide the things on. merit. This is all about this. Thank you.